Of workers today heeding a national call to strike and march against these new amendments to the Labour Relations Act and the national minimum wage, led by the man you've just seen there, Zwelinzima, Vavi, and his trade union federation, Saftu. Workers took to the streets in their numbers, refusing to accept the proposed minimum wage of 20 Rand an hour. Well, to help us unpack the LRA amendments, I'm now joined by Labour law specialist Osborne Molatudi. Thank you very much for joining us and welcome to the program.
Thank you, and thank you for the opportunity.
So this has become a really hot issue, but it's been one that's been discussed for quite a while, and it was supposed to be implemented next week on May Day, but that's been delayed. What's happened to delay it, and why has it become hot now when it's been in discussion for a while?
Once again, thank you, Peter, for the opportunity. I think what caused the government to delay the implementation of the national minimum wage bill is primarily because of the overwhelming submissions that they received, and especially in relation to what should constitute a national minimum wage. And the second reason is that, as you indicated earlier on in your insert, is that one of the federations, Saftu, I would imagine the reason why they're now protesting outside of the process, which was at NETLEC, is because at the time the agreement was reached on a number of issues pertaining to this bill. Saftu wasn't a member of NETLEC, and they're trying to use what we call a bargaining power, the right to protest, to put more pressure on the government to reconsider its position on what should constitute a minimum wage.
All right, let's take a look at, we'll chat about the minimum wage just now, but these amendments, you know, if you switch on TV, if you switch on radio, you're hearing different sides saying different things. Just give us, in broad terms, what are the key amendments to the LRA that are really on the table?
Peter, there are a fair number of the amendments contained in the Labour Relations Amendment Bill of 2017. However, the key ones that attracted Saftu's attention is the one relating to matters concerning a secret ballot, which one can loosely translate as the right to strike. So they see that as a limitation on the union to call for a strike. And by the way, it also affects employers, because what the section says is that a trade union and or an employer association that intends to either strike or lock out, it must have in its constitution a provision for a secret ballot to be conducted. Initially it was an open ballot. Now it even goes further to say that it must make a provision that the ballot, the casting of the vote, be secret. And to Saftu, to them that is tantamount to undermining the very basic right of workers to strike when it comes to matters of mutual interest. In other words, those issues that cannot be resolved by way of arbitration.
You're still allowed to strike. It's just the mechanism to get to the strike point that is what's being disputed.
Indeed, those in support of a secret ballot are saying that is important in order to ensure that the strike that is being called upon has a majority support of the workers. In other words, in order to promote the economy in this country, in order to avoid wildcat strike, what one can call a proliferation of so many strikes. Rather, let's have a provision that will seek to establish whether the strike or the lockout has the majority of the members in that particular workplace. And Saftu sees that as a fundamental undermining of that right to strike. Now, the legal question is, of course, is Saftu right? And we are saying that the best way for that to be tested is once this amendment become the law, then perhaps the best forum to test them is in a court of law. But at the moment, they are using their right to protest to put more pressure on the parties and members of NETLEC and the government to reconsider their position on this proposed amendment.
Okay, all right. So as we speak now, the proposed minimum wage has been delayed, so we don't know that the government's going to look at the submissions, and so it may take quite a while longer before it's implemented anyway. Is that what we're saying?
Indeed, I have already indicated that they may be finalized, the process may be finalized next year. And the reason being that there are some employers that still believe that they cannot afford the 20 Rand that is proposed to be the minimum wage. And what the government has done is to make provision for what you call exemption process, where you can then make an application not to, for the minimum wage not to apply to those who will be making application. Now, in order for that process to be in place, there has to be regulations, and the regulations can only be published once the bill has become the law. And also the government is cautious. Why pass a bill that may not pass a constitutional muster or that can be challenged later on? So they want to make sure that the entire process is inclusive as possible. All the submissions that were made are considered, and then it is at that point that the bill can then be enacted as law.
What happens to sectorial determination in all of this?
The National Minimum Wage Bill does make provision, what we call transitional provisions, for instance, for farm workers, domestic workers, where that which is offered to them in terms of the sectoral determinations can, on a face-to-face basis, later be replaced by the national minimum wage. So currently the proposal is that they should be paid a minimum of 18 Rand per hour and 15 Rand respectively. In other words, 18 Rand for farm workers and 15 Rand for domestic workers. Now, that is an impact on sectoral determination to the extent that they may make provision for favorable conditions in certain sectors, because there are other sectors of our economy that are governed by sectoral determination agreed at a bargaining council.
All right, I want to come back to this exemptions, because what we can have is a company A that's got good profits that will struggle to get an exemption to drop the salaries, and company B, for whatever reason, might be having losses just because they're inefficient, and they'll be given an exemption because they can't afford. And we've got the same workers doing the same job, but just at different companies, getting paid differently.
Indeed. The government, through the Department of Labour, has emphasized that the exemption process will not be there just for the taking. It's going to be a rigorous process. There's going to be a certain criteria that has to be met by an employer that will be applying for exemption. So they're going to look at a number of factors: liquidity, profitability, past financial statement, etc. So it won't be something that you make an application today and then tomorrow it's granted. So the department has emphasized that any employer that will fail to meet those criteria will have their application for exemption rejected. Yes, it is concerning that you may have two sets of employees doing the same job, but the other employer is exempted from paying the national minimum wage, and the other one probably even earns more than that. It is concerning. Yeah.
All right, okay. So, I mean, bottom line, it's still quite a way away at this stage, so we can continue to discuss this, and perhaps what's on the table at the moment is likely to change before it's legislated. Osborne, we're going to have to leave it there, unfortunately, but thanks very much indeed for coming in and sharing your insights with us, and I'm sure we'll have you again in the near future. Thanks so much.
It's our